versus Logan Malone, 232249. And appearance, or I'm sorry, sir, your name for the record, please. I'm sorry, that didn't come through.
Logan Malone.
All right, thank you. And sir, you are in court today on criminal charges, and you understand that you have the right to have an attorney represent you at all critical stages of the criminal process, correct?
That's correct, Your Honor.
Okay. And you also understand that if you cannot afford an attorney, one may be appointed to represent you at no cost.
Yeah, that's correct. I understand.
That's yes?
Yes, ma'am.
And, okay, and you want to waive your right to an attorney?
Yes, ma'am.
Okay. And sir, do you know why you're at court today, or do you want the court to read the reasons why you're here?
We'd like to read
All right, the court will note that it has a complaint that alleges on October 17th of this year at the Rite Aid on Biddle Avenue that you did commit retail fraud.
Who are you hearing?
And remove items from the store that you did not purchase. It's a misdemeanor charge. The maximum penalty upon conviction is not more than 93 days in jail and or a $500 fine or both. Do you understand that, sir?
Yes, ma'am.
All right, the court's going to enter a plea of not guilty.
Your Honor. Your Honor.
Yes.
I was just asking if you'd read me the charges. I wasn't saying guilty or not guilty yet. I want to take 110% ownership to what I did last night. And I just want to say like I'm guilty for that. Because I did go into that Rite Aid and take a Mountain Dew and then like a coffee and then some beef jerky. So I just want to apologize and own up to that.
Okay. And sir, I also wanted, I was not quite finished. I did tell you what your charges were, the maximum penalty. I was also trying to let you know that I was entering a plea of not guilty for purposes of the arraignment, and we're going to set it for a pretrial date. And I also, sir, want to make sure that you understood the rights on your advice of rights document that you signed. Did you read and understand all of those rights?
Yes, Your Honor.
Okay, so you also understand that you do have the right to remain silent. Anything you say orally or in writing may be used against you. You understand all that?
Yes, Your Honor. And I just want to own up to, what I did. Not waste anyone's time here and move forward with life.
Okay, I understand that, but I'm going to set this for pre-trial so you have an opportunity to speak to the prosecuting attorney. Or you can even, if you reconsider wanting an attorney, then you can also request an attorney at the pre-trial date, sir. And we're going to schedule this matter for pre-trial on October 24th at 10:30 a.m. And sir, do you live in Trenton? Is the address that we have for you, is that your current address?
2261 Medford Street.
Yes.
That's where I used to reside. Yes, Your Honor. I was actually currently yesterday trying to get into a rehab. All this kind of stuff slowed me down into getting to that process. But I'm currently
homeless. You're currently homeless?
At this point in time, yes. Yes, Your Honor.
Okay. And does somebody still reside at that address or no?
Yeah, my grandparents.
Okay. And sir, if you were to test today, what's in your system?
What's that?
If you were to test today, what would be detected in your system?
Be marijuana.
All right. And do you have a valid prescription for marijuana?
I do not know.
Okay. And you indicated that you were trying to get into rehab. And
Yes.
what type of rehab are you trying to get into, sir?
I was just trying to get some type of drug rehab. Because even though in my eyes I only smoked weed, it's still like a setback for me. I was, served on one sober and I failed. So I just wanted to get back on that right path. Just go into like some type of growth program, learn some new things about the body and mind.
Okay.
And try.
And I understand that you're homeless, sir. Do you work?
Up to 3 weeks ago, I was working. Then I just started smoking weed and just stay at my aunt's house and not doing nothing.
And where were you working, sir?
I was working at Evergreen Lawn Care.
Okay.
And that's located in Howell, Michigan. I was making a commute from Trenton to Howell every day.
Okay. And are you currently on probation anywhere, sir?
I don't know if my probation has ended. I was on probation for fleeing and looting, felony, and my probation officer texted me about 3 weeks ago saying that, he signed up on papers that it was all good to go, but I don't know for sure. The judge cleared off on that yet. And then I am on probation in Washington County for a misdemeanor. I get off that in like a month, so I'm on probation with them.
Okay, and what misdemeanor is that, sir?
That's for I'm trying to remember. It's for disorderly conduct. My bad.
Okay. All right, so the court is going to order the following bond. Based upon the fact that you don't have an address at this point, you're out on probation on a matter out of Washington County. The court is going to order a $5,000 10% bond. I will indicate, sir, that you may be tethered to treatment through the Wayne County Jail if you are requesting that.
Yeah, that's exactly what I'm trying to do.
You have to possess and consume the alcohol or drugs unless prescribed, and you're not to return to the Rite Aid.
Okay.
And you're to have a GPS tethered to the Wayne County Jail. Questions, sir?
Any questions?
And then a question with the tele-drop to post bond if I want to go to rehab.
No.
Okay.
Okay.
All right. Thank you.
All right, we'll see you Tuesday. Thank you. Have a good day. 109. And here.
Your Honor, for the record, John Goldthorpe, P. 30758, on behalf of Mr. Trim. Mr. Trim, would you please?
Okay, you just scoot a little closer, please, so that you.
I'm sorry.
That's okay.
My
All right, thank you, and good morning. Just please remove your hands from your pockets and take dates scheduled for a bond violation hearing as well as a sentencing on your client's plea of possession of controlled substance.
That is correct, Your Honor.
All right, let's handle the bond violation hearing first. So bond violation hearing.
Your Honor, it's alleged that on 2023, while on bond to this particular court, he tested positive for alcohol and marijuana on 9/22/23.
What is it you're looking at?
I'm looking at the notice from Ms. Shine, dated 10/13/23.
Right. Is that the file or is that something you received via email?
I received this via email from Ms. Shine.
No, it's not. So just one moment, we're gonna go off the record and I'm going to grab that. I can't hear you. Hold on, let's go back. That's okay. Are you ready to go back on the record? Yeah. Oh, okay. On the record, recall the matter 2311709. And I'm sorry, what was that, sir?
I apologize, I'm dressed and I was on my way to work outside.
Okay. No, I understand. Where do you work?
Ridge Waters, actually, I got fired from the other job because it like didn't have no police or any offense with the law, so I had to give me another job, so.
Which he did, and we are going.
So you're working at Bridgewater? Okay.
Yeah.
I'm taking that note on the, yes, okay.
Yes.
All right, so before we get distracted, we'll stay on track on the violation. So it's alleged at your, so you were ordered no alcohol or drugs unless prescribed at your arraignment on September 12th. It's alleged that on September 20th, you tested positive for alcohol and marijuana. And again, on the 22nd, you tested positive for alcohol and marijuana. And this time, both levels were up. And then you also tested positive for marijuana and alcohol, again, after September 22nd. What's that?
He said all those times I tested positive.
Yes. So counsel, what is happening with the bond violation?
Your Honor, I discussed this with Mr. Trim, and I reviewed the documents. It appears that he did test positive for alcohol and for cannabis on the date. I'm sorry, I lost it. On 9/20 and also on 9/22. Looking at these reports, I discussed this with him. He understood the terms and conditions of his bond and it's indicated he has no answer why he tested positive for marijuana. He did indicate to me that prior to being placed on bond, probation, prior to, he did smoke marijuana, does not have a medical marijuana card, but clearly understood that he was not to smoke marijuana, and it has indicated to me that though the levels seem to have risen, he has no idea how that happened unless it was contact. He does admit that he did drink alcohol. He has no excuse except that, as he will tell you, he was with a bunch of guys, had a couple.
3 times?
Oh,
The third date was September 28th.
oh, I didn't see.
September 20th, 22nd, and 28th. So, sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give this going to be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. All right. And so is your client pleading guilty? Is that what you're indicating?
He
counsel?
will plead guilty, Your Honor,
Okay,
but he cannot, he has no, he's guilty of the alcohol. He admits to that. He has no, this court has told me that he has no, he did not intentionally ingest the marijuana. However, that would still be a bond violation, even if it was contact.
all right. And sir, you heard the allegations regarding your bond violation, correct? And as to those allegations, how do you plead?
Yes.
You understand you have the right to have a contested hearing in this matter, and by entering into a plea, you will not have that contested hearing.
Yes.
You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
You understand that those were conditions of your bond, and that if the court could revoke your bond, the court could sentence you to jail, combination of both.
Yes.
And knowing all that, you still want to continue with your plea. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea today?
No.
All right, counsel, you can please go to your client.
Thank you. Mr. Trim, you were placed on positions of no alcohol and no drugs, right?
Correct.
And was there a point in time, once you were placed on bond, that you drank knowingly alcohol,
Yes.
and that was beer?
Yes.
And was this on more than one occasion?
More than one day.
Been satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violation. And so, sir, you got together with the guys and you had some beers.
Yeah, my dog died, so I was just kind of messed up.
And when did your dog die? I'm sorry?
13
The 13th. Okay, and how old was your dog?
years old.
And that was the entire 8 years?
Yes.
Okay. And had he been ill, or was it sudden?
No. Marvel.
Oh, yeah, Parvo. Okay, and what kind of dog was it? His name?
Her name was Bella.
Oh, her name, Bella. Okay. All right. Well, sir, I can understand that that's upsetting. I mean, I had a dog that was 14 years old pass away,
Yeah.
right?
It's heartbreaking. It's like it's really part of you.
It is. However, that's not a justification or an excusable
You were
basis to consume alcohol when you've been ordered not to.
correct.
And it wasn't just one time, it was 3 times.
Right.
The counsel asked, why should I not send your client to jail?
Your Honor, we're here today for the sentencing as well. I understand those conditions. I would ask rather than to send him to jail, he's appeared today knowing this was coming. And I don't say that jokingly. I would ask rather than if we're going to follow the sentencing agreement, the probation recommendation, that he should be fined rather than sending him to jail for this bond violation. With that end, be under the sentence. It was it's not an excuse, but at least he has come forth, admitted all of this, and knowing all of that is remorseful for his actions. Is that correct, sir?
Well, okay, but, so I'd like to know, what was, what was going through your mind when you thought, when you were drinking the beer?
I don't know. I was just wasn't thinking.
And Your Honor, this is not this statement. This is just a statement. When I addressed this issue with him, he said, well, I didn't drink any alcohol. I had a couple of beers. I know that alcohol, I explained to him that alcohol, I mean, beer is alcohol. And that's not an excuse. He drank beer and he admitted that. His statement to me was, well, it wasn't alcohol, it was beer. And I'm just saying that when this, what's going through your mind, he wasn't thinking and he drank the beer. And I know that's a silly statement to make. And I'm just letting you know how he reacted when I told him what these bond violation.
Sir, you seem to think that beer is not considered alcohol? I'm a little confused.
I didn't think it was alcohol. I just thought this is for beer.
And I guess as opposed to vodka or rum or, that's the only thing I can reflect on.
Okay, but sir, you understand that alcohol, that beer contains alcohol.
Yes, some beer looks like not all beer.
Okay, what beer doesn't contain alcohol?
Heineken is 0% alcohol. They have Heineken like that.
Certain Heinekens, correct. And there's, I mean, there are many, you know, you have, Coors has non-alcoholic, you have O'Doul's, which is non-alcoholic. You have, I think it's Bud Zero maybe, or Bud Light Zero or something, or, right. So there are a number of non-alcoholic beers. But there are a lot more alcoholic beers. So were you drinking non-alcoholic beer?
No.
Okay then. So. Did you think you were permitted to drink beer?
No.
Okay.
I was hurt. I apologize.
Well, sir, I'm going to presume that your attorney is going to argue that that the court should adopt the recommendation for probation. You've already violated bond 3 times. And so I have some serious concerns that you'll be able to comply with the probation conditions.
Ryan, he also understands very well that should he violate terms and conditions of probation, and the recommendation is taken under the city ordinance 25136B, that if he does not make it through the probationary term, then he's going to lose his driving privileges as well, because he has pled to a possession of controlled substance, and under the statute, regardless of whether or not he was operating a motor vehicle at the time, there is a provision from the Secretary of State that any conviction for a drug case would result in a 1-year suspension. He needs his license. He spent a lot of money getting his license back, and so he is very positive in completing your probation and attention to complete it in the shortest period of time possible. So I suggest this court, we will not see him here again until the matter is dismissed.
Wow. The court speaks through its orders, and if the court doesn't enforce its orders, then why even have conditions and orders? So I'm going to order 3 days for each of the allegations for the bond violation, so the total of 9 days on the bond violation.
Could we postpone that for a period of time, as we're going to address in this time of probation? He lost his job at Oxford because of the police contact. Nothing other than that. He did nothing wrong. He lost a job that was paying him quite a bit of money per hour. He didn't sit around. He didn't do anything. And he didn't sit around on his bottom and well, I'll come to court and then I'll go and find a job. He immediately went out, found another job at a lot less money, but that's what's available. He's taking those actions at this point in time that if he is to go to jail, on bond violation under the circumstances, then he'll lose that job as well. So if we could at least look at a jail review regarding the bond violation down the road during the period of his probationary period, then I think that he will show you clearly that he is positively doing everything that you are ordering him to do. This was a relapse and judged clearly, and I would ask that that be how this began.
Okay, and counsel, I can appreciate all that. However, your client was aware of bond conditions. Very aware of bond conditions. And despite that, he consumed alcohol. Not once, but 3 separate occasions. 3 separate occasions. And so if your client ends up losing this job, that is not on the court. That's your client's choice to violate this court's order 3 separate times.
No, I understand that, John. I understand completely what you're saying. It is his problem. It wasn't the court that created the problem. I'm only asking leniency from this court and allowing him to prove to this court that he shouldn't be given 9 days prior to us resolving, or at least letting him show this court that he's going to make it through. It's still out there, and the court could sometime during the term of probation on this charge and say, well, I know you're doing everything here, but I still think you should be going to jail for this bond violation. That's all I'm asking for. I'm asking for some leniency and help from this court to make sure that he can stay working and make sure that he's going to be successful in completing his probationary period.
Well, and that will be during probation if this court orders probation. But for the bond violation, I did give leniency, and I indicated 3 days each violation, as opposed to a lengthier jail term. So I already did exercise some leniency. So now, as to the report and recommendation.
Your Honor, we've had an opportunity to present the report. There is one correction, and that indicated that at the time the report was prepared, he was working at Foxwell Industries. At that point in time, he was discharged. He was fired because of police contact. Nothing more, nothing less. There was nothing improper at his workplace. However, he's already suffered that because of his actions. He didn't wait around. He immediately went out and got another job. He's working 40 hours a week, full time. He's working, which is surprising because he's working at Bridgewater factory in Detroit, and it makes parts for the auto industry. He has not been laid off, and it has not affected his business at this time. We're asking that the recommendation under
25.136B
be adopted, and it is recommended that he should be sentenced under that statute. I've explained to him that statute in great detail. He is eligible, and we would ask that the recommendation be adopted.
Okay, after hearing from counsel and hearing from Mr. Trim and reviewing the report and recommendation, the court does find there is reasonable grounds to park on scale 769.5. The court finds the recommendation is appropriate. The court will order 18 months probation. You're eligible for early discharge. You're also eligible under the local ordinance of 25.136B. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're notified probation officer immediately if any change in address or employment status. You are not to use any alcohol or drugs unless prescribed. You'll be subjected to random testing. Just for clarification, that includes any beer. And just so you're aware, sir, the non-alcoholic beer, some of that still contains alcohol. The rehabilitative role for that condition, so the court can monitor your progress in maintaining absence and sobriety. You'll have to enroll and participate in outpatient substance use counseling. The rehabilitative role for that condition is for you to receive assistance in providing coping mechanisms so that you may maintain sobriety and prevent relapse. The court's going to also indicate 5 days on the court workforce. The rehabilitative goal for that condition is to further develop work and life skills and get back to the community. And the court's going to also indicate mandatory incarceration for any future violation of probation, and also revocation of your under advisement status. Any questions?
Yes, last, what you just said, what did you mean about that?
So if you have any probation violations, all right, then we'll have a revocation of your under advisement status. So right now, this matter is being taken as what they call under advisement pursuant to the local ordinance.
Okay.
If you successfully complete your probation, that would be dismissed off of your record,
Okay.
okay? If you violate probation, even one time, that under advisement status will be revoked and it won't be coming off your record at all,
I understand.
okay?
And if that
And,
happens,
go ahead.
and if that happens, then your license becomes suspended.
Right, and that's also, sir, if there's a probation violation, there would also be mandatory incarceration as well, okay?
Okay.
All right, so that's what that last provision was.
Okay. I understand.
Okay. The court's going to indicate a $300 fine, $100 screening assessment fee, supervision oversight fee of $900. That's $50 a month and 18 months. Since you're eligible for early discharge, up to $450 of that may not be due.
Okay.
Okay? $200 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, workforce $200. It's 5 days at $40 a day. For a total of $1,825. And you did post a $500 bond. Do you have any other money to pay today? One sec. Okay, so I will indicate a total of $600 today when we apply the $100 bond, $100 cash, or however you make the payment, and the $500 bond, okay?
Okay.
Which leaves a balance of $1,225. How much can you pay per month? Well, here's what I'm going to do. I'm going to have you set up a payment plan. By the end of November, in the event you do not have your job when you are released, then you'll need time to get that job and then set up a payment plan,
Okay.
okay?
I'm actually trying to pay it off sometime.
You can always pay it off.
Yes. There's no prepayment penalty. Right, you can. Just hold back $450. I'm just indicating that you can pay it earlier. There's not a prepayment penalty. That's fine.
Okay.
Yes. All right, anything else?
No, Your Honor, I understand the fine. I still request once more some sort of jail review with respect to that. And
Council, I would have considered it for one, but there's three. So
I understand, I'm just making my plea.
you are.
And Your Honor, when would the student be here? Would the court give him a day or two to go to Wayne County Jail to report so that he can make arrangements for with his employer that he will not be available for a period of time?
Report Friday, October 20th. It doesn't mean between now and Friday, use anything that you're not supposed to be using.
No, he understands it clearly.
Okay. All right. And as I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed all of your terms of probation. You've had at least 3 months without any violations. All monies have been paid in full. We've made good faith effort toward making full payment, and you've completed at least half of your original term of probation. Okay?
Thank you, Your Honor.
All right.
I have one more question.
Yes.
Would I need a paper with everything?
Yes, you're going to go meet with probation. They will give you that
All
information.
right, thank you.
All right, good luck to you, sir. All right, let's go off the record for a moment.